Hello, my name is Marvin Powell, and I'm an intellectual property law attorney. I've been practicing for over 20 years, and I would like to take this opportunity to talk with you about intellectual property law. There are several forms of intellectual property law. For example, there are patents, there are trademarks, there are copyrights, and there are also trade secrets. What I'm going to do today is to talk with you about trademarks. I will have a series on copyrights, I'll have a series on patents, and I'll also have a series on trade secrets. But for today, again, I'm going to talk to you about trademarks. First of all, let's start off with what is a trademark? A trademark is a way to identify your goods. And the definition as found under the United States Code, specifically 15 USC section 1127, is that a trademark is any word, name, symbol, or design used in commerce to identify and distinguish the goods of one manufacturer or seller over those of another. In other words, a trademark indicates the source of goods. For example, one of the patented and known trademarks is McDonald's. When you go in McDonald's, you're going to see everything from the burger being made consistently the same way. You're going to see the French fries made the same way. You're going to see the coloring scheme, the coloring scheme of the restaurant. And you're also going to see the big symbol that designates McDonald's as an eating place, the big M. All of those things are trademarks. Now, trademarks can also be used to represent the company. For example, Ford Motor Company uses Ford as both a trademark and also they use it as the trade name. For those of you that are interested in other kinds of trademarks, a trademark can be anything. IBM is a trademark. NBC is a trademark. CBS is a trademark. Fox is a trademark. All of these trademarks are ways that companies identify the source and quality and product that they're putting out. As an entrepreneur, why would you register a trademark? Well, one of the reasons for registering a trademark is that it gives you the exclusive right to those goods or services that you're currently marketing in commerce. You can't get an exclusive right to goods and services. I talk to my clients all the time, and one of the key things is that, well, Marvin, I don't have to register this as a trademark. I can freely use it in commerce. Well, that's very true. However, you can only use it in the limited commerce that you have. In other words, as a common law trademark, you can't exclude anyone from using it except in the territory that you're using it in. So let's stick for a moment with the registration. For example, one of the slogans, Maxwell House Coffee, good to the last drop, registered as a trademark. You can also register colors. I mentioned earlier McDonald's and the color scheme of the orange and the brown. Just remember, Pepsi-Cola's can, the colors, trademark. Coca-Cola's cans, the color, is also a trademark. As I mentioned earlier, you can have a trademark, quote unquote, that you use in common law. But when you register a trademark, there are several advantages. And one of the main advantages is that you can exclude someone from using that trademark. You can sue them in the United States District Court in what we call a trademark infringement suit. Let me give you an example of what was developing into a trademark infringement suit in a movie that Eddie Murphy was in called Coming to America. If you remember the restaurant of his American girlfriend then, it was called McDougal's. And the restaurant had the same colors as McDonald's. It had the same arrangement as McDonald's. All of the people that were working there wore the same type of uniforms as McDonald's. And throughout the entire movie, there was this young man that was trying to serve the owner of McDougal's with a cease and desist order from using the colors, from using the M with the color scheme of being orange and brown. That is an example of trademark infringement, as well as notice that you're about to get sued. One of the things about using a trademark is that it distinguishes your goods. It identifies your goods as having originated with you. And one of the reasons you always want to protect it, and as I said in the movie, Coming to America and Mr. McDougal versus Mr. McDonald, is that you always want to be sure that you can maintain the quality. You also want to be sure that you don't let anyone take advantage of your quality by using your trademark. Remember, trademark infringement is big business. And what you don't want to do is be in a situation where your trademark is being used without your permission. I had mentioned early the common law use of trademarks. I do not recommend it, but when you consider how much it costs to file a trademark in the patent office, it may be a consideration. The trademark filing fees range anywhere from $225 to $400 to file a trademark or a slogan in the U.S. Patent and Trademark Office. Remember, this is a benefit that you're seeking to be able to exclude someone from using and identifying their goods in a way that would confuse them with yours. What I'd like to do next is to talk about the do's and the don'ts of owning a trademark. First of all, a trademark is an adjective as a part of speech. It is not a noun. As I said, you use a trademark as an adjective. Let me give you some classic examples when the owner of the trademark failed to prevent individuals from using it as a noun. It becomes generic and you lose the trademark. For example, the word thermos. Most of the time, most of those kind of products don't exist in wide variety, but a thermos is something that you put an item in to either maintain it as being cold or hot. The original name was called thermos container, but no one used the word container. They finally call it a thermos, and lo and behold, it became generic, and therefore the rights to that particular item was lost. Let me give you a more near-term example of what I mean when you misuse a trademark as a noun versus an adjective. One of the things that Xerox does over and over is to tell everyone that you make a Xerox copy of paper. You do not Xerox the paper. Doesn't sound like very much, but the point is, one, when you Xerox the copy of paper, you're talking about using it as an adjective, whereas when you use the term, go Xerox this, quote unquote, now it becomes a noun, and Xerox is very diligent in stopping individuals from using their trademarks as a noun. If you consistently use a trademark as an adjective, as is proper you can maintain the trademark forever. That means there's no limit no time limit as to when the trademark expires. This is to your advantage because as you build up your quality in your product, your quality in your service, you'll be able to keep the same trademark that you had year after year after year. One of the classic problems with having a trademark is sometimes people forget and misspell it. Don't misspell your trademark. I guess I'm starting into those don'ts now. Don't use it as a noun. Don't misspell it. Don't use it as plural. In other words, Xeroxes copy paper. That is a misuse of the trademark. One of the things I want to share with you in this first presentation of trademarks is that one of the items that can be trademarked, it can be a phrase, it can be a word, it can be a symbol, it can be a device, it can be a color. What you're trying to do is to distinguish your goods over someone else's goods. What you're trying to do is to build up your reputation, build up the quality in your trademark, your goods, your services, so that it will have value. In other words, it will appear on your balance sheet as actually being a part of the value of your particular company. I know that there may be questions or things that I didn't cover or that I did cover and you would like to follow up with me on. I'm going to give you my email address. It's very simple. Marvin, my middle initial is J, as in Joseph. Marvin J. Powell, the number 13, at Verizon.net. Again, Marvin J. Powell, the number 13, at Verizon.net. Please feel free to write me, ask me questions about trademarks. Feel free to do so. It's no cost. My initial consultation, should I say, with all potential clients is free. I think it's bad business to act otherwise. So feel free to send me an email, ask me a question about a trademark, and I'll be sure to get to it. Again, my name is Marvin Powell. I've been practicing patent, trademark, copyright, trade secret law for over 20 years. I enjoyed making this video. And again, to contact me, Marvin J. Powell, the number 13, at Verizon.net. Thank you very much. Have a great day.